Good morning, all. I'm Saranya from SIKI. On behalf of Southern Indian Chamber of Commerce and Industry, I'm welcoming you all for IBC Updates Recent Amendments and Judgments session. Now I request Mr. V. N. Shivashankar, Vice President, Southern India Chamber of Commerce and Industry, to give the welcome remarks. I welcome you, sir.
Good morning to all of you. Mr. Rajesh Kumar Gupta, Chief General Manager, IBBI, Mr. Ramchandar, Co-Chair, SIKI MSME Expert Committee, Mr. Kalyan Jabak, Partner Surana and Surana, Mr. Himanshu Srivastav, Partner ASA Associates, Mr. Neeraj Kumar, Partner DSK Legal, and friends. It's my great pleasure to welcome you all to this webinar on IBC Updates, Recent Amendments and Judgments. As we are all aware, the Insolvency and Bankruptcy Code that has been in vogue since 2016 aims at a significant overhaul of the existing legal framework of insolvency and bankruptcy resolution. The landmark legislation encompassing the earlier BAFR powers and also extends to individuals now. Prior to IBC, we had multiple laws dealing with corporate sickness, or as BFR for industrial enterprises, Companies Act for the other non-industrial companies. We also have the SURFACI for recovery by banks and institutions. It is precisely owing to the lack of success and the time taken under BIFR and under the normal liquidation process under Companies Act that IBC has been introduced to provide for a more transparent institutional mechanism for resolution for businesses, either by coming up with a viable survival mechanism or by ensuring their prompt liquidation. So this has now put creditors firmly in control of the process as opposed to the situation prevailing earlier. This has certainly helped India's ease of doing business index to improve considerably. The need for stress resolution is much more in the current COVID scenario, and whatever economic recovery we had seen post the first wave has taken a severe beating, and any sustained recovery for India can take place only if stressed businesses are able to restructure their debts properly. Reserve Bank of India had earlier come out with a package which actually helped a lot of SMEs continue to operate. IBC is really the key to solving these challenges. Therefore, the new pre-packaged insolvency mechanism to the IBC code is a very welcome measure. This pre-packaged mechanism seeks to provide a hybrid corporate rescue process to MSMEs due to their varied structure of business model when compared to the bigger conglomerate. Also wish to add that MSMEs today are a significant contributor to the country's GDP, and all agencies, including the RBI, are stressing on increasing liquidity availability to the MSMEs. Earlier, Reserve Bank of India permitted only banks to lend to MSMEs. Now, recently, they have permitted NBFCs as well to lend to MSMEs, and this comes under priority sector lending for the bank. Therefore, MSMEs are able to access funds at lower cost coming under priority sector. We have experts with us here today to shed more light on the topic and provide greater understanding on the recent trends in this area. Before concluding, permit me to say a few words about SIKI. SIKI has completed 110 years of service to the industry. Founded in 1909 under the inspiration of Mahatma Gandhi, we have inherited a rich tradition while at the same time remaining youthful, dynamic, and embracing change. SIKI has led the way in converting challenges presented by the pandemic, turning them into opportunities, and we have been working on multiple projects, knowledge reports, and furthering our flagship event. Last year, SIKI was fortunate to work with Guidance Tamil Nadu to engage with the Tamil diaspora outreach by conducting the flagship Yadum Ure Conclave, which was attended by over 4,000 participants from 38 countries. We are working closely with Chennai Corporation for setting up sister cities desks connecting cities of Tamil Nadu with other cities of the world. And we are also working closely with the Department of Culture in Tamil Nadu to build an industry museum in Egmore, which will be the first of its kind. On this note, I thank all the participants who have taken time and efforts to join this program. I thank you all for being with us today and look forward to your continued support in the days to come. Over to the panel of experts for today's session. Thank you.
Thank you, sir. Thank you for your warm welcome. Now I request Mr. Kalyan Jabak, partner, Surana and Surana International Attorneys, to give the inaugural address. A brief profile about him. Mr. Kalyan is practicing advocate since 1990. He is a certified independent director and he is advising several large international and domestic clients for the corporate, commercial, insurance, intellectual property, and dispute resolution requirements. And he is also a sole arbitrator in several arbitrations, and he successfully mediated and settled several commercial, corporate, family, and social disputes. I request you to give the inaugural address, sir.
Good morning to one and all present. Respected Mr. Rajesh Kumar Gupta, Chief General Manager, Insolvency and Bankruptcy Board of India. Mr. V.N. Shiv Kumar, sir. Shiv Shankar, sir. Mr. Himanshu Srivat, sir. Mr. Neeraj Kumar, partner, DSK Legal. Both of them would be answering the question and answer questions. And we have Mr. Ramchandran, who will be the moderator. Now, this pre-packaged, the Insolvency and Bankruptcy Code, which has come, that is the Insolvency and Bankruptcy Code Amendment Ordinance 2021. Now, this has been a very big step that has been taken, and this has been coming on the heels of various other reforms and amendments to the IBC. The PPIP, as we may call it for the MSMEs, has been introduced to provide them an alternative, effective insolvency resolution process, so that value maximization, which is the main objective of the code, is achieved quicker and in a cost-effective manner with least disruption to the business. The code emphasizes on reorganization and insolvency resolution of the corporate debtor while maximizing the value of assets of the corporate debtor and promoting entrepreneurship, availability of credit, and balancing the interest of all stakeholders in the CIP process. The promoters, managements have less say in the corporate debtor and is managed by the professional RP. And the RP at times, due to the lack of experience in that particular industry, cannot take prompt action, even if able to do so, may not like to take the same unless consent is taken from the committee of creditors to avoid any unwanted consequences, allegations for which he may be made responsible. Even though in the CIP process, this corporate debtor needs to be a going concern so that it can fetch a good resolution plan. But in most of the cases, except the big CDs of the CRP, no new business operations are undertaken. The object of revival may not be achieved in case of MSME if the concept of both the control and possession of the creditors is implemented. It is to overcome the difficulties of CIRP in case of similar structures of MSME that the current ordinance has been passed, which as a hybrid framework, blending both the formal and informal process within the basic mechanisms of the Insolvency and Bankruptcy Code. I would like to place a few of the highlights over here under the ordinance, which has been there. Now, this is one which is of a debtor in possession, unlike in the RP, in the CIRP, where the IRP or the RP is in possession, which has earlier been followed. Here, the corporate debtor gets an opportunity to submit a resolution plan. A strict timeline of 120 days has been envisaged and provided for, and a threshold limit of 10 lakhs has been fixed as per the guideline issued. It is an efficient alternative to the insolvency process of corporate persons who have been recently of micro, small, and medium enterprises under the Insolvency and Bankruptcy Code. It ensures quicker, cost-effective, and value maximization for all the stakeholders in a manner which is least disruptive to the continuity of business. The current process is a consensual approach to financial stress of a company, and in view of this, it is expected that the process is edged. In this, there have been several checks and balances. So, in this context, all I place panel before all the members is the recent amendments would bring about a mindset change, not only for the corporate debtors, but it is equally important that the financial creditors, they also have a mindset change. The financial creditors and the corporate debtors should not look at the financial creditors as a mere source of e-body. Now, this is going to be the thing which would count as the PPA is enforced in greater. Normally, the MSMEs constitute more than 60% of the manufacturing activity in the country. And in the recent COVID times, this has created a lot of financial stress on most of the MSMEs. The CIRP route, it may not lead to a win-win situation for both the financial creditor, operational creditor, and the corporate debtor. The pre-packaged insolvency resolution plan is one such amendment that wants to bring about a mindset change in the way the corporate debtor and the financial creditor work. The corporate debtor, that is the MSME, must ensure that they have a proper corporate governance and not that the corporate debtor is treated or dealt with as a sole proprietorship or partnership firm. A lot of discipline, self-imposed, would have to be followed and focus must be on the business. Similarly, the financial creditors and operational creditors would look at the corporate debtors as partners in their business, and there needs to be openness, reasonable amount of transparency and trust between both of them. A few of the key points of the current ordinances that the debtor is in possession, that the corporate is in possession, unlike the earlier one. They get an opportunity, the corporate debtor gets an opportunity to submit a resolution plan. A strict timeline is followed of 120 days for completion of the process. A 90 days timeline is given for submission of the resolution plan, and within 30 days, the NCLT is to approve of the same. It is an there have been sufficient checks and balances in the entire process, starting right from the very beginning of wherein a lot of disclosures have to come from the corporate data, which currently is a major stumbling block in the CIRP process, where the IRP is not able to collect all the details and file its first report itself. Moving forward, the entire process is one of trust by both sides, and the corporate debtor himself gives the entire plan to the entire details. In fact, it is a huge opportunity for resolution professionals also to start working, because they start working with the corporate debtor even before, at the time of the preparation of the plan itself, and they coordinate along with the financial creditors. The checks and balances are in the form of, you have to give the corporate debtor has to give a lot of disclosures and ensure that there's no false representation, including that of transactions which may be colorable. Now, in India, this is where there'll be a huge mindset change which must come both in the by the corporate debtors, wherein most of them would have a lot of accounting issues which may fall well within the 29A category, and to that extent, there'll be a lot of Sorry, my apologies for that. There's been a little change. Now, as far as this is concerned, now the plan is given. It is in principle approved by the financial creditors, and thereafter, the plan is submitted before the adjudicating authorities, and within 2 days the plan has to be given, and within a period of 7 days the adjudicating authorities give any defects, or they admit the Ppiip as it is called. Thereafter, within the period of 90 days, the committee of creditors would meet and approve of the plan. If the base plan which is given by the corporate debtor is found to be insufficient or in any lacking, they are entitled to call upon them to increase the offer or to better the plan. And here also they have something which we call as the Swiss system, wherein in case for any reason the financial creditors agree to or accept the plan, then at that point of time they can call for the plan from the others. In this is where they have the major difference in compared to the earlier system, is where they have the evaluation process which is being going on, and the banks have to look into the process. They have the COC with a 66% can approve of the plan and or modify it, ask for a significantly better plan in relation to it. Now, under the plans which has been given under the PPIRP, in case there is any haircut, then they are entitled to call for third-party applicants to give their plan approvals to. It is not that they are entitled to, and in case there is any haircut to the corporate, to the financial creditors, there must be a equal sacrifice that needs to be made by the corporate debtor. Now, in this context, the management remains with the corporate debtor, and to that extent, the MSMEs would feel comfortable in trying to restructure their plan. Now, this would be something which would come into being and would remain with most of the banks wanting to opt for this manner, because often we see that whether it is for the restructuring or otherwise, the banks and financial creditors often have an hesitation because of this the lack of consensus, or a committee is not formed to give the approvals. Now, under this scheme, with the judicial seal of approval, the banks would also come forward much easier, and it would be easier to give a seal of approval. The only small things which I thought I should place it before the tribunal and here before the other members before I close, would be that the Act, while filing of the plan, wants a lot of disclosures to be made, so that in case they got a lot of penalties in case there is a non-disclosure of any of the transactions which are colorable, then a huge penalty is leviable upon the directors and the officers concerned. The only reservations would all the MSMEs who are often a little bit disorganized, I would say, not very well in the corporate structure in the strict sense, the way the larger companies are, would they be able to give all those details, and then would such disclosures hold them up for any other action? That is something which needs to be looked into. Such preferential transaction declarations, how it will be looked into. Now, these are a few small things, but as the code is introduced, I'm sure this is one of the acts which has seen a lot of amendments, which has been very necessary. And this is one more amendment which has come. As the code has been introduced, it will take some time to settle down. And before this PPPIP model is fully evolved, and with the help of clarifications from the committee, from judicial interpretations, the MSME community can really look forward to this wonderful act where it would be a win-win situation for both, in the sense like rather than the thing being too late for the company to be revived or to be restructured, at the very beginning itself, the corporate debtor comes forward and places it before the financial creditors, and a plan is worked out so that it is favorable for both. With these few words, I would end and leave my inaugural thing and leave the rest to the other panelists to take up.
Hi, good morning. My name is Himanshu, and I'm a partner with ASA. I take care of the business advisory service. Before I introduce myself, I thank Mr. Siva from SICC and also other team members who have made all the efforts to put this together. I also thank Mr. Kalyan Jabak for a very comprehensive overview. I would definitely be, touching upon certain of these aspects in my slides. And then I also thank, I'm very honored to
Sir, sorry, sir.
have Mr.
Sorry to
Gupta
interrupt
from
you.
IBPI. Yes.
Sir, sorry to interrupt you. Actually, I'm requesting Mr. Rajesh Kumar Gupta to give the guest of honor, sir, from Insolvency and Bankruptcy Board of India, please, sir. Can you hold on, please?
Yes, please. Yes, please. Yes, please. Thank you so much. I would have recommended that, so kindly do that.
I request Mr. Rajesh Kumar Gupta, Chief General Manager, Insolvency and Bankruptcy Board of India, to give the guest of honor. I request you to take it forward, sir, please.
Yeah, thank you. Am I audible? Am I audible?
Yes, sir, you are audible.
Yes, sir.
Thank you. Respected Mr. V.N. Shivashankar, Vice President, SICCI, Mr. Kalyan Jabak, Partner Surana and Surana International Attorneys, Mr. Himanshu Srivastava, Partner ASA Associates, Mr. Neeraj Kumar, Partner DSK Legal, Mr. Ramchandar, Co-Chair SICCI MSME Expert Committee, and all distinguished participants from the industry. Greetings and a very good morning to all of you. At the outset, I would like to thank the Southern India Chamber of Commerce and Industry, SICCI, for their effort in creating awareness and sensitizing the intended beneficiaries, that is the MSME industry, about the pre-packaged insolvency resolution mechanism by organizing this webinar in a very timely manner. Being a part of the regulator, the IBPI under the Insolvency and Bankruptcy Code, I would like to give you a bird's eye view of the process and the background which led to the promulgation of the Insolvency and Bankruptcy Code Amendment, Ordinance 2021, introducing pre-packaged insolvency resolution process for MSMEs. There may be some duplication in whatever Mr. Jabak had recently just now told, but nevertheless, I'll try to explain in a little different language. The unprecedented emergence of the COVID-19 pandemic last year and the re-emergence of the second wave this year, the imposition of rigorous lockdowns, shutting down of factories and livelihoods, have resulted in acute contraction of the economic activity, not only within India, but abroad also. The Indian economy is also estimated to have contracted by 10.3% as per the IMF, 9.6% as per the World Bank, and 9% as per the Asian Development Bank in the financial year 2020-21, which is a huge kind of a contraction. Considering the impending economic slowdown and the potential rise in corporate insolvencies, the Government of India announced the suspension of filing fresh applications, as we all are aware, for initiation of fresh corporate insolvency resolution processes in respect of defaults arising after 25th March 2020. The suspension extended for a period of 1 year and got over on 24th of March 2021 this year. The suspension was implemented with the primary aim of insulating companies, especially vulnerable micro, small and medium enterprises, from financial stress during the pandemic. This was also to ensure that a large number of perfectly successful, cash flow oriented, and viable enterprises are not forced into insolvency resolution on account of temporary distress faced by them pursuant to the COVID pandemic, shutdowns, lockdowns, and the stoppage of economic activities. In anticipation of the surge in the number of insolvency applications after the suspension has been lifted on March 25, 2021, a need was recognized for a hybrid framework which combines out-of-court restructuring schemes with the sanctity of a formal process. Further, considering the huge contribution of MSMEs to India's GDP growth, employment generation, and exports, and the fact that they may not have the requisite endurance to survive prolonged insolvency proceedings as stipulated under the Code, the Insolvency and Bankruptcy Code Amendment, Ordinance 2021 was promulgated on 4th of April 2021, introducing prepackaged insolvency resolution process for the MSMEs. The ordinance aims to provide an efficient alternative insolvency resolution mechanism for the MSME sector, ensuring quicker, cost-effective, and value-maximizing outcome for all the stakeholders in a manner which is least disruptive to the continuity of their business and helps preserve jobs and the organizational capital. In keeping with the primary objective of the code, the prepackaged insolvency resolution process, or the PPIRP as we call it, seeks to encourage resolution of the corporate debtor with liquidation only as the last resort. That is, generally there may not be a liquidation as an outcome of this particular process. It offers adequate opportunities for amendment of the base resolution plan submitted by the corporate debtor, adequate time for examination, and a Swiss challenge method for identification of the most viable plan, and also safeguards against any fraudulent activity, etc. Also, since a major portion of the process occurs outside the court, the stakeholders have adequate time and a better opportunity to negotiate among themselves for a suitable outcome and a win-win situation for all. The pre-pack process strives to preserve value of the MSMEs by saving costs, preventing delays, and avoiding business disruptions. It envisages a pre-agreed base resolution plan, which results in minimized litigation and confidentiality of the process until the formal process commences. The pre-packaged insolvency resolution process helps the MSMEs to negotiate and agree upon a mutually beneficial resolution plan before beginning the formal process. Upon arriving at a consensus, the PPIRP can be conducted smoothly with minimum uncertainties, limited costs and disputes, and while maximum the value of the corporate debtor. The PPIRP, as I've already been mentioned earlier, promotes a debtor in possession model for insolvency resolution. That is, during the PPIRP period, the control of the affairs of the CD shall vest with its board of directors or its partners, who shall take all the requisite measures to preserve the value of the assets of the corporate debtor and manage its affairs as a going concern. Further, the model also offers an incentive for the corporate debtor to initiate the PPIRP himself, as the existing management can continue to control the business, conduct the business, and with an opportunity to retain the company after the process is over. While the incumbent management of the corporate debtor enjoys control, the committee of creditors, comprising of unrelated lenders, supervises its actions, where the COC at any time during the PPIRP is satisfied that the affairs of the corporate debtor have been conducted fraudulently, or where the processes have been managed in a manner that there is a severe mismanagement of the corporate debtor, resulting in depletion of the value of assets of the CD to the detriment of the creditors. The RP resolved to place the management of the corporate debtor in the RP via an application to the adjudicating authority. So the whole emphasis of the entire process is on trust and a free and a fair process without any kind of fraudulent activity or stripping of the assets or such other things. The entire process foundation is a trust. Furthermore, the approval or rejection of a resolution plan under the PPIRP also rests upon the commercial wisdom of the committee of creditors. The ordinance stipulates an integration of the debtor in possession model with the creditor control approach during the pre-pack insolvency process, and such a hybrid framework ensures that a corporate debtor makes genuine efforts to resolve the stress while vesting sufficient powers in the hands of the committee of creditors to ensure successful and timely resolution of the corporate debtor in all their commercial wisdom. As already mentioned, the PPIRP process proposes the negotiation of a resolution plan between the corporate debtor and the creditor prior to the commitment of the statutory proceedings. A switch model has also been introduced to ensure transparency and maximization of values of the assets of the CD. As per this model, the COC may approve the base resolution plan submitted by the corporate applicant if it does not impair any claims owed to the operational creditor and offers the best value, or else the COC may invite prospective resolution applicants for submission of resolution plans under a Swiss challenge mechanism. Upon receipt of the alternate resolution plans, the COC evaluates and compares them with the base resolution plan based on a matrix which is pre-decided, and in the end, the most feasible plan is sanctioned for resolution of the corporate debtor. And upon receiving the approval of the COC, the resolution RP submits the approved resolution plan to the adjudicating authority seeking its approval. Coming to the operational part, it is most likely the corporate debtor who may initiate the PPIRP process, as it may be the only entity concerned about the revival of the company. The corporate debtor best understands the economic situation of the company and can potentially offer the most effective, viable, and long-term lasting solution. Initiation of the PPIRP requires default of at least rupees 10 lakh, prior approval of at least 66% of the unrelated financial creditors and 75% of its directors or partners. Lastly, the corporate debtor must submit a base resolution plan before the financial creditors prior to seeking their approval. Although ARP does not take charge of the management of the corporate debtor upon initiation of the PPIRP, his role is very crucial and critical to maintain transparency and fairness of the process. The resolution professional shoulders the responsibility of protecting the interests of the creditors, shareholders, and the business, as well as ensuring compliance with the laws as regards to the process. The resolution professional acts in an advisory capacity before the commencement of the formal procedure and aids the corporate debtor in negotiation of the base resolution plan and in completion of the pre-admission formalities. His formal role begins with the admission of the PPIRP and includes confirming and maintaining an updated list of claims, constituting the COC, convening and attending meetings, preparing the information memorandum and the evaluation matrix, etc. One of the key considerations of the PPIRP is to reduce deals caused by litigation and court procedure, thereby maximizing the value of the assets of the CD. Since the corporate debtor and the creditors would have negotiated the initiation of the PPIRP along with the base resolution plan beforehand, the process is likely to witness minimum disruptions, uncertain complete sooner. The ordinance prescribes a time limit of 120 days from the prepackaged insolvency commencement date, including 30 days for the approval by the adjudicating authority. If no plan is approved by the COC within 90 days, the resolution professional shall apply to the adjudicating authority for termination of the PPIRP on expiry of such period. The prepack mechanism is expected to be a win-win situation for the NCLT, the borrower, and the creditors. For the NCLT, the prepacks will ease its existing burden, as the resolution plans would have been pre-decided by the creditors and would lead to speedy resolutions. For the borrower, the process helps the MSME borrower to retain control of the enterprise till a settlement is reached. It also increases his chance to retain control of the company through a resolution process or by getting an investor on board. For lenders, this will be good news too, as the resolution typically happens faster. To summarize, the government seeks to explore alternatives to the conventional corporate insolvency resolution process by way of the introduction of prepackaged insolvency resolution framework. The ordinance lays special emphasis on rehabilitation of the MSMEs, considering the unique nature of their business and their contribution to India's economic growth. Recognizing that such companies lack the resources to endure prolonged periods of stress, the PPIRP aims to offer a semi-formal resolution mechanism with minimal costs, delays, and disputes. All aspects considered, the prepackaged process promises a more mature and robust insolvency regime. The government has actively promoted the establishment and protection of MSMEs due to their significant contributions towards the GDP growth, employment opportunities, and exports. Considering their simpler corporate structure, the conventional CIRP model will not yield the desired outcome in a timely manner. Therefore, to insulate the MSMEs from liquidation, an alternative resolution mechanism has been introduced. The ordinance promotes healthy competition between the incumbent management and the prospective resolution applicants for revival of the company. In anticipation of a better competing offer, the existing promoters shall endeavor to propose the most viable solution in the first instance, thereby preventing delays, saving costs, and preserving jobs. To conclude, I urge you all MSMEs to have a relook at your cash flows and financial health of your companies and try to avoid any defaults to the extent practicable and possible. If facing financial distress, do explore the possibility of using this Ppiip framework in a timely manner to ensure insolvency resolution while protecting your interests, preserving organization capital, rescuing jobs, and taking care of interests of all your stakeholders, including the lenders. In the end, I would also like to thank the organizers for organizing this particular event at an opportune time, and would also like to offer that we can also organize a similar kind of a program with around 60 to 90 minutes, which we have been organizing for other MSME associations across the country along with SIDBI, to give answers to the queries which the MSME promoters or the managements may be having regarding introduction and implementation of the Ppiip insolvency framework. Thank you.
Thank you, sir, and thank you for addressing us about the objectives and importance of insolvency code for MSMEs. Now we are moving to the next session. It's a panel discussion. Now I'm inviting Mr. Srivatsava, partner SA Associates, Mr. Neeraj Kumar, partner DSK Legal, and Mr. Ramchandar, co-chairman SICI MSME Expert Committee, to take the panel discussion. Mr. Ramchandar, sir, I request you to take it forward, please.
Thank you, and good morning to all present here. I'd like to welcome Mr. Himanshu and Mr. Neeraj to the panel discussion. Mr. Himanshu is a partner at ASA Associates. He's the director of the Business Advisory Services at ASA Associates. He's been a chartered accountant and an insolvency professional with specialization in corporate law, structured advisory solutions, regulatory approvals, and helped many foreign investors in the areas of setup, restructuring, mergers, and cross-border joint ventures. He's had experience in working with 100 plus foreign multinationals and project managed about 40 plus factory setups for manufacturing companies in automotive and auto ancillaries. Our next expert, Mr. Neeraj Kumar, is a partner at DSK Legal from their New Delhi office, is a well-established, peer-recognized record and transition practice. He has extensive experience in real estate, education, and manufacturing. Before joining DSK, Mr. Neeraj has been with PricewaterhouseCoopers and Fox Mulder. So welcome, gentlemen. I'd like to first invite Mr. Himanshu Srivatsava to give the opening remarks. Over to you, Mr. Himanshu.
Well, thank you very much. Ranya, I'm so sorry I could not hear you last time, so I by mistake unmute myself. But nevertheless, it was very important and nice to hear Mr. R.K. Gupta's view. I just would thank again Mr. Shiv Shankar and Mr. Ramchandar. And of course, Mr. Kalyan Jabak and the Honorable Mr. R.K. Gupta from IBBI. So it's my pleasure to be amongst you. Since now the regulator has spoken, it's not very much advisable that I should be speaking on these topics in too much detail. But the beauty of Mr. R.K. Gupta's address was that he addressed many concerns which I was hesitant to take up in my presentation due to paucity of time, and also the role of insolvency professional, which is very crucial. Being an insolvency professional myself, I really wanted not to stress that aspect as to how important the whole institution and the framework is. Nevertheless, I did prepared certain slides. I'm not sure if we are presenting that today. If anyone has my slides, it will be a right way to summarize this important topic of PIRP. So just allow me to present my views. I promise you that it would not take more than 15 minutes. So as we give Neeraj, the expert on the IBC, ample amount of time. So next slide, please. So basically, as we have already seen, this is just an overview, is that PIRP prepackaged insolvency resolution process is basically a part of IBC code itself. And we all know that the reason behind IBC was primarily, to address the financial failures or business failures. There are certain, logics and objective of IBC, as in it is considered to be a timely and very fair and impartial process of remedial measures for corporate debtors. And of course, the regulator IBBI, represented by Mr. Gupta today, and insolvency professionals ecosystem, as well as information utility, serves as a vital aid in regulation and implementation of this code. Next slide, please. So this is a framework. I thought, just to give you a broad overview of these framework, as in there are five part in the IBC, followed by a section on the schedule, and part 2 basically, as you can see, contains CIRP process liquidation, as well as pre-pack insolvency process has now been included here. Similarly, as we all know, that the CIRP, the corporate insolvency resolution process, can only be initiated by 3 kind of applicant, which is under section 7, 9, and 10. Financial creditors, operational creditors, and corporate debtors themselves. Next slide, please. So this is a broad overview of the process under corporate insolvency resolution process. Is that usually on the request of any of the applicant, the honorable adjudicating authority would admit an application, and at times the appointment of insolvency resolution professional is directed, or at times it is even recommended by the applicant themselves. Then broadly, there are constitution of committee of creditors, which would confirm the resolution professional, and then resolution professional was tasked to prepare all the information. Even Mr. Jabak has mentioned it was very onerous task, because he was saddled, in the chair of driving this whole process without any aid to him from the erstwhile management or officers, even though the law is very clear and stringent to enable the resolution professional to get all facilitation. But there were challenges, and as we are seeing now, these has been addressed in the pre-pack. So coming to the CIRP, then once the IM is formed and resolution plans are invited, then they are voted, and then based on the decision of COC, either they are approved and forwarded to NCLT, who would either reject, then it leads to liquidation, or approval, then it becomes implementation. So this was a broad framework, and we have seen that despite the best intention of the regulator and the whole IBC mechanism, the process was not being not yielding the desired outcomes, or we've seen research papers issued by the IBBI that most of the cases were actually, the number of cases of revival were very limited, and mostly it was going into liquidation. So there was a bit of concern that should this be applied in toto to MSME, would there be similar kind of experiences as were seen in the CIRP? Next slide. So this is the model timeline. I've taken it from the code, and I can see a lot of lawyers and IPs are attending this. So I would not dwell deeper into it. That's a secret of curtailing my presentation into 15 minutes. Is that next slide? So these are the model timelines of the CIRP. Next slide, please. So as you can see that the total in the 3 slides, I would have covered the whole process of the CIRP, and it is the ideal time frame is about 180 days. Extended can be extended, until 330 days now. Next slide. Yeah. So just a repetition of what my fellow panelists and speakers have said before is that Ppiip or pre-packaged insolvency resolution process is specifically for the benefit of the MSMEs. And the economy is reeling under pressure for COVID-19. Every aspect of the society has been stressed healthcare systems, as well as including the supply chains, the businesses, the entrepreneurship, totally has been tested in this time for last 1 year. And the government was very proactive by taking several measures to mitigate this distress as to how they can, they have limitation, and government is the limitation or the beauty of governance is that it cannot be in the business itself. So what they did was to give a very good framework or platform or manage somehow so that there are not undue responses or reactions to the pandemic. So there was a suspension of CRP process for about a year, and this March it has been lifted. So out of now, how it is important for MSME is that based on several of my research and of course attending, I have observed that MSME all across India have been stressed, and despite the fact that they are 60% of the active companies in India, as per the definition, they are the most vulnerable section when it comes to application of CIRP process. So since MSME are backbone of any country, and I have seen even in many foreign countries such as Japan or Germany or even US, that the supply chain is not really dominated by big names that we see. It's the MSME in their jurisdiction as they categorize it. So it's important for India as well to address this in our own sort of way. So this led to an alternate insolvency resolution process for MSME, and I would say that the government has been very proactive. It's just been 3 months since this framework was announced and it was implemented. So it has been a very excellent and proactive response from the government. And as I explained in my framework slide, is that new chapter has been added to the IBC, and it's a very historic moment even for the IBC legislation. Next slide. So what is prepackaged, insolvency resolution process in my own word? And you may be aware of these, but for the larger audience, I would say that MSME prepack is only available to an MSME by definition. And such an MSME should actually be registered with the Udyam portal, that is, have a license of being treated as an SME. So these are the threshold for investment in plant and machinery, and as well as turnover. These figures are in rupees. So I would say that when evaluating prepack as a mechanism to restructure, one really need to see the first and fundamental step as to whether they are actually eligible. So I struggled to find this limit in the IBC initially, but then I noted that the central government, it's available on the MCA portal, is that the 10 lakh or 1 million is the minimum threshold for default to kickstart the PPIRP process. A declaration by majority of the directors or partners is that a company, this has been covered by the previous speaker, is that there are number of declarations which are required to be prepared and submitted by the directors of the company or partners of LLP, and based on it, they have to give a primary declaration that they will file an application for initiation of PIRP within 90 days. So such is the beauty of this code, is that from the initial date when the management decides, the clock starts ticking, and there is a time frame of 90 days for them to actually apply for this, the whole process. So there are certain conditions as were there earlier in other processes. It should not be initiated to defraud anyone. And of course, you need an insolvency professionals who is not having any disciplinary proceedings and is approved as a resolution professional. Followed by a special resolution by the owner or promoter group, more than 75%, and 66% of approval from unrelated financial creditor. Then the fundamental issue is that you have to have a base resolution plan, which in principle has been approved by the unrelated financial creditors. Next slide, please. Next slide, please. Yeah. So, in nutshell, what is the advantage of Ppiip is that this has already been mentioned. It's only a graphical, pictorial presentation of what has been spoken by my fellow speakers. Is that the beauty is that the management of the affairs of the corporate debtor or the enterprise going for PIRP continues to be with the same management. And it's a very key aspect of any MSME, because technically there are no takers, because MSME market is so niche or so unique that you cannot really apply one fit all solution to the MSME sector. So the management can continue to drive the business and operations. Of course, there are certain checks and balances and restrictions and limitations on their powers and activities, but broadly what it gives to the all stakeholders, that there is there's an endeavor to protect the value of the business as well as the assets from unnecessary distress dilution, and it can be managed as a going concern. And the last point, the promoter, members, personnel law and partners, they have to discharge their contractual rights and duties as per the prescribed guidelines in the code. So technically, I would say that all this stress which we have seen over the, and it's been 5 years for the IBC itself, is that this new endeavor really helps you to combine best of not just both world but all the world. I mean, it's a win-win for every stakeholder that may be involved. Next. So vesting of the management can also go to the resolution professionals should there be any instances wherein, let's say, the RP feels that the affairs of corporate debtors are being conducted in fraudulent manner, or there has been a gross management. So I think Mr. Gupta mentioned and Mr. Ramchandra mentioned that trust is the most important factor in the implementation of these processes. And I think if that is broken, then the regulatory mechanism takes the front seat and drive this business. So once these powers are vested in the RPs, then he manages the affair of the corporate debtor as a going concern, and he exercises all other powers, including asking the managers and officers of the company to provide the RP with all the support and information. And during the process of moratorium, the essential supplies cannot be discontinued unless, just to aid, and there are certain proviso that these services should not be the main input for the output. So technically, it should not be an electricity company or water supply company or telecommunication company. So these are the fundamental things so as to keep them as a going concern. Next slide. Yeah, so the time limit of Ppiip has been given in the code itself, is that it's 120 days from the Ppiip commencement date. We will look at what is commencement date. And the resolution professionals shall submit the resolution plan as approved by Committee of Creditors to the adjudicating authority within a period of 90 days from the commencement date. So if no resolution plan is approved by the Committee of Creditors within 90 days, the RP has to request the termination of the process by making an application to the adjudicating authority. Next slide. Yeah, so these are certain aspects of what should be included in the resolution plan, and as Mr. Gupta has urged all the MSME to evaluate this piece of legislation. So when they are evaluating it, all they need to evaluate is this, that they have to take care of how the assets of the corporate debtor are to be transferred or retained, sale or disposal, restructuring by way of merger, amalgamation, or substantial acquisition, cancellation of any or delisting of any shares, or curing or waiving any breach of terms. So there is a complete list, and I can say that both the regulation for PPIRP as well as the code are actually complementary to each other, and there have been no inconsistency whatsoever, as have been after what has been clarified. So one need to really, this is the most important slide in the whole PPIRP process, is that all that a resolution plan has to take care. Next slide. So then, these are the model timeline in my case. And the reason I mentioned it phase 2 is that while I was hearing the other speaker, I just flipped my slide is that, there are certain, these are my own inferences of the legal provision as to once the application is admitted by adjudicating authority, that is a commencement date. Within next 2 days, you have to provide the RP with a list of claims and preliminary information memorandum and base resolution plan. Technically, that means that these things should already be evaluated and be in place before you actually commence the PPIRP. Then the RP, somewhere I don't, no, sorry. Yes, please remain here. Then, RP has to appoint certain valuers to get disposal or realizable value of the assets. He has to constitute the committee of creditors, and then within 7 days of constitution, one has to call the first meeting of COC. So what I'm trying to say is, besides showing my knowledge, I'm just trying to emphasize the fact that there are certain timelines and thresholds to complete all these aspects in a very time-bound manner. So unless, if you really go by the scheme, you can see that the code and the regulation are very, very clear as to how you have to conclude it in a period of 120 days. So the last process is like technically approval of resolution plan by adjudicating authority. So which is technically within 30 days of submission if and provided all things are in place and are in order. So, but if you really, remove this period of 30 days, there is definitely, I would say 90 days threshold to submit the plan with the adjudicating authority. And of course, adjudicating authority may have several reasons, to decide, or, it may take slightly longer, but on part of the corporate debtor, which is the proposing authority for PPRP, applicant for the PPRP, they have to complete everything within a time frame of shorter than 3 months. So there cannot be any compromise, and nowhere in the provision there is anything which calls for an extension of this time period. Of course, they can apply to the NCLT, and of course, there can be certain exception, but the bottom line is that 90 days from the date of commencement date is the final and the benchmark for you to complete all the process. So from technical perspective, assuming in my impression that there would be certain MSMEs attending, I thought that I would also elaborate on certain steps which are required before that. Next slide, please. Yes. So technically, this is all, in my view, would be an ideal time frame to conduct an PPIRP. So as you saw that 120 days for the whole process to run. But before that, there is a lot of homework to be done, as in you need to check whether you are eligible to conduct a pre-pack. And then, assuming that you would take about a month to check it and ensure, all the internal documentation and records are in place. You would also probably seek professional help to define, draft a base resolution plan, and, maybe take a buy-in from the promoters and stakeholders. Then declaration of directors and partners. As you can see, I've given a 45 days time frame for the whole process to run, and maybe, vetting and tweaking details here and there, refining the BRP if required. Then approval of members. Then followed, these all followed by approval of financial creditors, wherein all these approvals, prior approvals have to be placed. Appointment of resolution professional. And then a resolution professional has to make a report which will be filed before the adjudicating authority during the application. So once you make an application, within 14 days, the NCL2 has to accept or reject it. And if it is accepted, then technically it is treated as a commencement date. So if you really link it with my previous slide, which was a follow through of what happens once the commencement date starts, you would, you would get a fair picture. So in my view, this is my personal view, that this whole process is, not going to take any less than 7 to 8 months at the minimum. So it may take longer. So consider it, and evaluate it very seriously. But the merits or the benefit of this PPRP is that it gives you a continuity of business and all the benefits as has been elaborated earlier. Next slide, please. So, this is a very important slide, assuming again, for MSME, if they are attending, is that it evaluates what are the difference between CIRP and PPIRP. Is that eligibility? Of course, as I mentioned, there are three kinds of applicant in CIRP, and for PIRP, it's only MSME corporate data itself. Applicant could be, as I've already covered, resolution plan has to be prepared after commencement of CIRP. Wherein in this case, base resolution plan exists before the initiation of or the commencement date itself. Then, what Mr. Gupta also mentioned and Mr. Jhabak also mentioned, that the beauty of this is that you can improve the plan. There is a scoring mechanism, an improvement mechanism, a Swiss challenge, as we've been hearing, a term which is not there in the code, but we have an alternative term, improvement of plan, which was not there in CIRP. And there is an aspect of improvement of plan in the PPIRP. Role of NCLT is very, very elaborate, and the NCLTs and the adjudicating authority network or the ecosystem is quite stressed because of CIRP, and that's one of the reasons why things have been delayed in audit without elaborating any motive there. But in case of PPIRP, the role is quite limited, and the onus really falls on the management and the resolution professional. If they can tick all the boxes correctly, then the time limit which is there for you to see 120 days is very much achievable. Another thing which I noticed, that the conversion of PPIRP into CIRP is very much there in PPIRP, which is not there in case of CIRP. And certainty, I would say that CIRP process is, the outcome is not certain, but here we are quite sure about the outcome. Business quantity is high in CIRP, of course higher in PPIRP, and the control which remains with the creditor or the corporate debtor, but in case of PPIRP, the management of the CD remains with the management itself. Next slide, please. Yeah, so these are certain checks for one to really evaluate how to prepare for PPIRP. Of course, you need to seek help of IP and professional to make a base resolution plan which is in compliance with IBC and regulation. And this is the most serious aspect of this whole regulation, that there is no room for any default. Because any non-compliance would lead to either termination of PPIRP, and then you are not allowed for initiating it for next 3 years, or it gets unknowingly or unwantedly, it may lead to a liquidation itself. So be very careful. See your eligibility, verify all the transactions very carefully, and take ameliorative measures for that. Drafting of preliminary information memorandum and base resolution plan, and of course, not to miss that financial, legal, and tax due diligence. You have to be very sure before you get into this, because it's a double-edged sword. The advantages are significant, so are the exposures. And then prepare a viable and business revival plan, approach the financial creditors with the plan, and then evaluate, consider improvement in the plan, and that's it. And then let the IP take its own, the steps, and the law takes its own course. Next slide, please. Yeah, so that's it about my presentation. I could do justice, as in I was given 20-25 minutes to speak. I could have really elongated my presentation, but thanks to other speakers who really helped me to cover the other aspects which were not covered in my slides. And thank you very much for your patience. I would now hand over, Saranya, if you would welcome Mr. Neeraj Gupta. Mr. Neeraj Kumar, sorry.
Yes, sir. Thank you, sir. Thank you for the presentation. Now I am welcoming Mr. Neeraj Kumar, partner, DSK Legal, to present, please.
Thank you. Thank you, Saranya. Thank you, SICC, for organizing this seminar. Thank you for inviting me to speak here. I think a lot has already been covered by the speakers before me and also by my co-panelist, Himanshu. I have a presentation that was more to give a general outlook on the landmark cases in the insolvency bankruptcy court. Given that the theme till now has been predominantly for MSME sector, in fact, I will confine myself I will not go to my presentation, but confine myself to comment upon how IBC and MSME basically has interplayed till now, and I mean, what is the road? What is the road like? What is the it will look forward? I mean, with this introduction of pre-pack. So when IBC was promulgated in 2016, there was no specific dispensation for any industry or any class of industries. The first wave of amendment came in the wake of the home buyers issue or the consumer for the real estate sector. Both IBBI as well as the policymakers have been really nimble-footed. They have responded to the demands of the economy and the industry, and they have, and that basically reflects also in the number of amendments that have been carried out in IBC till now. So with that amendment, basically for the first time, a special category of financial creditors was recognized, which were the home buyers or the consumers of the real estate industry. Going forward, there was an amendment by which a section 29A was inserted in IBC, which debarred the promoters with certain handicap not to participate in the resolution plan of their own company. The successful resolution of large accounts like SR and Bhushan basically may have actually given the thought or given an impression that everything is hunky-dory with the current regime. But given the abject failure or very minuscule recovery in the loan accounts of MSME, basically it was thought that it is time that a special dispensation is created for this subspecies of industry. And that brought in the first dispensation when the MSME was taken out of the ambit of 29A. However, given the lending culture that we have in this country and the element of distrust that builds in between borrower and lender, if account is not going as per the design or as expected, it is not only that you are declared an NPA by a lender. There are other actions also which get initiated parallelly, like actions under SURFACE, actions under willful defaulter declaration, or account being declared as fraud. So all this also came in the way of bringing the distrust between borrower and lender, especially for MSME sector. And that also basically led to a situation where despite the specific dispensation under section 29A, the promoters were effectively barred from participating in the resolution of their own account. That is what the thought process was when basically there was a call made to the both regulator as well as to policymakers for bringing in a special dispensation or a pre-packed kind of what has been introduced by the Insolvency and Bankruptcy Code now. So Mr. Gupta from IBBI has already spoken extensively about that pre-pack, and also my co-panelist Himanshu. So that's my opening remark, and Saranya, I can pass it on to the other co-panelists that we have here, who can also share his thoughts on this. Saranya, if you can just invite the other co-panelist to share his opening thoughts, then we can actually have an open discussion or question and answer session.
Sure, sir, sure. I request Mr. Ramchandar, co-chairman, SICI MSME Expert Committee, to take the proceedings, sir.
Thank you, Sharanya. Gentlemen, it was wonderful listening to both of you. I think there was a lot of insight given to this IBC and how to proceed for MSME. To start with some basic questions, I'd first like to ask Mr. Neeraj, probably, when does an MSME really identify himself that he has to go into such a resolution plan or should he consider MSMEs are ideally single man owned or small partnership companies that are owned by a group of friends or members of the family or something like that. So do they really have a point at which they can identify whether they have to go into a resolution plan, or they should even start thinking about a liquidation process? How do you think they can identify such a difference?
Right, sir. As you have rightly pointed out, sir, because it's a family-run kind of outfit and where basically it's closely controlled business, the person who is running the business has the best knowledge about whether the business is going to continue in a fair weather scenario or he is going to face some difficulties going forward. As soon as that realization dawns on him, and he actually, as Mr. Gupta had pointed out when he was speaking about this, that as soon as you realize there is going to be a cash flow mismatch or asset liability mismatch, moment you have that realization, that's the right time to actually start the process. So it's like a preventive maintenance issue rather than a breakdown maintenance issue. So
that's a very nice anecdote to the whole question. Thank you very much, sir. One more question I have for you, sir. I mean, sir, somewhere in the presentation, we were always spoken about there is this 90-day time frame before which this expires. The whole thing expires if the documentation is not properly completed and submitted and things like that. Do you think, I also heard that if we are not making proper disclosures, we are debarred from reapplying for 3 years or something like that. But in the case of a 90-day expiry, do you think we can reapply, or is there again a holiday period that we cannot reapply for a time?
I will request Himanshu to take this question because that was what was covered by him rather than me.
Okay.
Sorry, I was having some challenge with my PC.
Okay.
So technically, in my view, once the whole process is terminated for lack of transparency or let's say breach of conditions by the management, I would say that the bar of peers would apply. It's not a continuous process of that you would keep on doing this, and once you've exercised it and technically you've exhausted that option for next 3 years.
Okay. Thank you very much. And this question of operational creditors is again something that is having a gray area. Is it only for secured creditors like the financial institutions and the NBFCs, or even the unsecured creditors come into picture, even to the extent of material suppliers or something like that for manufacturing firms? Do they also come under the operational creditors umbrella?
So, Neeraj, go over to you.
Sure, sir. I will take that question. So, if you look at what basically constitute a financial creditor and who are basically operational creditor, so in Supreme Court in Swiss Ribbons has deliberated on that issue, and elaborating on the whole concept. There are two things which makes a person a financial creditor. One is a disbursement of loan or disbursement of money. It may not be to the borrower itself, it may be to a third party as well. For example, in a hire purchase or something, where the money is paid to the supplier rather than the borrower itself. And the second is that that money being loaned is for a time value of money. That is basically, it carries a coupon and it has a repayment mechanism inbuilt in it. And that in case it is not basically repaid by the borrower, then it becomes a it has a time value attached to it. There is an accrual around that. Apart from all this, whatever the other borrowers of the company are or the debtors of the company are, in whatever nature, that will qualify as a operational creditor. Now, one tricky issue which I'd like to point out here is many a times MSMEs set up their industries in industrial corridor or industrial zones, where the government industrial body has basically allotted the land, and where the land can be paid over a period of time of 7-8 years. It has a basically payment plan attached to it, to the allotment. What happens to such category of debtors. For example, I basically practice in Delhi. So in an area like Noida, for example, or Greater Noida, there the land is allotted to a industry, and the industry fails to pay the installment which is due in say 6th, 7th year, and there is an insolvency process going on. Then all that due is getting lodged by the authority as a financial creditor. They say that there is a interest which is inbuilt in that, and they should qualify as a financial creditor. That position has been differently interpreted by NCLT and NCLAT. Now the matter is before Supreme Court. So we'll see how finally that issue settles. But as a broad principle, as a general principle, as a first rule, any supplier of goods and services to a corporate debtor will qualify as an operational creditor, and any financial creditor will be one who has lent money and who actually carries, and that disbursement carries a coupon.
And further, that the operational creditor are really important in this PPIRP. I mean, they cannot be excluded, because one has to really, before approving of the plan, the NCLT sees whether there have been any impairment of the claims of the operational creditors as well. And, if the management is not changing and there has been an impairment of the claims of operational creditor, so NCLT would check, if there is a proportionate dilution of the equity or control of the promoter as well. So to that extent, the code and the regulation takes care of this aspect, as that no one should be left behind, or one really, minorities cannot be ignored.
Okay, thank you, sir. That was also. And now coming to the very classic question on every MSME owner's mind is, how expensive is this process going to be? I'm already in soup, and am I going to spend a lot here as well going into this resolution? I mean, being people who are in the resolution field, what could be a thumb rule, a ballpark figure for this kind of a resolution?
I need to be careful about the code of ethics of the IBBI. This really, as it would not be very ethical on my part to be marketing anything on this forum. But yes, if there are any concern, my email addresses are there. Then we have to really evaluate each case as it is unique. And the severity of let's say the extent of the operation and everything will go into determining the scope of work. And I've given a broad outline of what can be the scope of work, as in the whole background check and the due diligence process, preparation. You have to see that there are kind of technically three kind of processes involved. One is this pre-pack preparation, wherein you have to do this base resolution plan, you have to prepare information memorandum, check the eligibility, and overall prepare the organization for to be ready for the pre-pack. Then the second phase is about the implementation of that process, and the third process is follow through and something called post pre-pack integration, as I would say. So it all depends, and there is, as I mentioned, since there is no one fit for all solution, there is no one fit cost and fee as well. So if there are any specific queries, one can be look at that. But Neeraj, if you have any views, since you are doing a lot of it, please.
Right. So, sir, I think it's a very valid concern, first of all. And in fact, now that we have Mr. Gupta here, in fact, that can be an appeal made to IBBI as well, like what they have prescribed as the fee for the liquidation process, as the liquidator's fee. Similarly, something of that sort can be prescribed even if even for this process, if the process is being conducted by the resolution professional. And as long as that it doesn't involve a resolution professional to come in, that can be cost controlled by the promoter himself.
Okay. So there is a question from Neeraj from one Mr. Benjamin Moses, who's in the audience. He is requesting the name of the case in which Supreme Court has defined who could be the creditors. Is there the...
Right. So that is Swiss Ribbons case.
Okay.
And in fact, that's actually part of my presentation. I can actually circulate that to him in case he can drop me an email ID. I can send it to him.
Yeah, sure, sir. I think he's there, so he should have also heard your answer, and he'll probably touch base with you. Another open question from one Mr. Durai Babu. His question is: if only pro forma invoice is made in order to avoid payment of GST, income tax, for uncertainty of the amount receivable, do they qualify for filing petition? Or probably he's trying to ask if that qualifies within that 66% of amount that goes in for filing the thing.
Right. So I think these are the real questions that basically I expected from MSMEs to come in, because these are the real life scenarios. So you're right. If it's just a pro forma invoice and which has not been confirmed by the recipient, and you have not raised it on account of that basically GST liability should not accrue. That will be a tricky situation for you to qualify as a creditor and to bring in an action. So I think because anything with any practice that you basically are indulging in where you're trying to bypass a legal route, I will be finding it difficult to sustain that in court of law, saying that, okay, why only on the basis of pro forma invoice that basically you come before me. What need to be understood is that action by operational creditor is not a suo motu action like what is by a financial creditor. So in financial creditor, basically financial creditor need not put the corporate debtor on notice. He can simply go and file an application in the NCLT, and then basically you file your reply and you have to defend yourself. Whereas an operational creditor has to first issue a notice to the corporate debtor, where corporate debtor can also basically dispute it. So so when you issue that notice, basically corporate debtor will definitely flag the issue that I have not even received your invoice. So how my obligation to make the payment arises, So there is a technical snap there. Yeah.
Okay. Sir, okay. Another thing that lingers around a lot of MSME owners, because mostly they're owner-driven businesses are, once you go for a resolution plan, and then unfortunately this goes into ending up as a liquidation process itself, and there is a huge mismatch or even a percentage mismatch of what is going to be paid for the creditors, assuming the amount is going to be lesser than what the company actually owes as a debtor. Does this provide legal immunity after the entire process is over? The resolution plan is completed, then guided, then it's gone to the liquidation stage, and then the amount settled off to the creditors. Does this provide legal immunity on that specific to the promoter on account of that company, on that account of that corporate?
Right. So look, recently there was a pronouncement of the Supreme Court in Lalit Kumar Jain case, where the insolvency of a personal guarantor who stood guarantee to a borrowing by a corporate debtor which is under insolvency or insolvency resolution or liquidation basically has been upheld. So effectively now today, any lender can bring simultaneous action against the company as well as the guarantor. So to answer you precisely, it will largely depend upon which creditor that we are talking about, which debtor we are talking about, and whether that promoter has actually issued guarantee to such a loan, for the loans or the borrowings of the corporate debtor. If that is the case, then I think a simultaneous resolution is the key to go for a lasting peace. Otherwise, it will be a follow-up action on your personal account as well.
Okay. Thank you, sir. And there is another question from one Mr. Muthu. I am a financial consultant. If the mandate is not signed, but we have proof of providing service, can we file a case?
Well, sir, yes, you can, if there is a proof and that is undisputed.
Okay. I think, okay, now from the legal immunity, a very similar question with a slightly twisted question on mine. Does this resolution process, provide a better exit route for the business in case the promoters want to, exit the business because of financial difficulty? Is this a method that they can choose to exit the business? I mean, use this resolution process as a exit route, if being a financially stressed business, otherwise they'll have a more profitable way of getting out.
So my thoughts, and obviously Himanshu can join with his views as well. So my thought process, this is a very good way out for the promoters whose business has been in difficult circumstances and who want a kind of lasting peace for themselves. So what they can bargain in the whole process is that a resolution for the company and for the business, which may actually entail some kind of exit for them from their personal guarantees and the obligations they are under.
Mr. Himanshu, your thoughts? Okay, you're having some problem, I guess, with your...
need to be unmuted, I believe.
Oh, okay, unmuted.
If
Saranya, you should unmute Mr. Himanshu.
Yeah. Now I think I can speak. So I certainly, agree with Neeraj there. As in, I think pre-pack is a very, very apt and appropriate way to actually get rid of all these liabilities, and especially what Neeraj just mentioned, the Lalit Kumar Jain case. I mean, because of this, the judgment, I would say that most of the CIRPs would prefer PIRPs, because the exposure on promoter and the personal guarantors is now very huge. So this could be a very profitable and a very secure way for all the parties to settle and close the chapters once and for all. Because otherwise the liabilities would continue. They can the personal guarantor at least can be brought to task anytime. Should there be any breach of the conditions.
Okay, sir. So any other thing that you would like to, I think most of our, I have one more question from one Ms. Rajeshwari. Sir, since the initiative is taken by the CD here, is limitation period applicable?
Well, now limitation law in insolvency has been built in. Initially, there was slightly a bit of confusion whether basically there is an issue of limitation will kick in IBC or not. Now that has been clarified by way of amendment itself, and as has been if you look at the judgment of the Supreme Court in Arsil versus Vishal Jaiswal, that makes it very clear that in case the latest balance sheet of the company reflects you as a creditor, then that is an admission on their part, and that issue of limitation will be addressed accordingly. So what basically Supreme Court has said that, the argument from the borrower was that I have to prepare a balance sheet in accordance with what basically Companies Act says. And that's why I actually put that that acknowledgement, but that is not an acknowledgement as per the Section 18 of the Limitation Act, to which the Supreme Court very well clarified that preparation of balance sheet is something which is mandated by law, but how it is to be prepared, that is not mandated by law. In case if the borrower thought that this action by the lender is time barred and it will not be carried out in the balance sheet, it should not be actually continued in the balance sheet, it should be taken off the balance sheet. So in case the balance sheet, recent balance sheet, or within 3 years, if there is the actionable claim, reflects that amount, then basically you have a valid ground of, that limitation can be judged accordingly.
There is a question which says, please explain MSME Council. Is there anything?
Right. So if I may take that question. So basically government somewhere believes, if I have understood the question correctly, so a government somewhere believes that MSME is a class of entrepreneurs that need to be basically given a special treatment. And that's why they have provided for a special forum for dispute resolution for the recoveries that for the services they do to larger corporates. And that is what MSME Council is, where basically you lodge your complaint to them for a service rendered to another party and the money that is to be recovered. So that is the specialized forum for MSMEs for their recoveries.
Okay, and where exactly is this council usually, how to approach this council, and where exactly are they present? Is it region based or?
Well, one is definitely in Chandigarh where I have appeared. So I'm sure it must be in different.
So it's more of a region based issue.
I'm sure it must be. I'm not very sure about that, but it should be. I mean, if there is one in Chandigarh, then I'm sure that there must be one in Chennai as well.
Oh, sure. Yes, sir. So I think we've had some fruitful discussions over the last 15-20 minutes, and there was some knowledge sharing that was definitely done. Would you like to have any closing remarks on your presentation, sir? Any final points? Mr. Neeraj first, and then probably on to Mr. Himanshu.
Sure. I will take a cue from what Mr. Gupta had spoken in when he was talking about this new initiative of the government. That MSME, I think they have to bring in some cultural change in the way the business they have been conducting in view of the onset of IBC. First as an IBC, as well as secondly in view of this pre-pack that has been introduced. We Indians generally have a tendency of not recording many conversations that we have, even business conversations. It is a good idea to get into a habit of recording those, because as I said, an action by operational creditor is only possible if you have not disputed the deficiency in their service. So in case there is a deficiency in service, it's better to record it over mail or over whatever means of communication. So, and these are the small changes that need to come in. Like earlier, people used to just pick up the phone and talk to their suppliers and say, okay, things are not as it was basically specified to be. All this need to change. You need to record your business transactions. And somewhere we have to get into a culture where the business is conducted in conformity with law, rather than trying to save our time by way of trying to avoid some tax or GST issues, as one of the questions that was raised. If all those basically you do you get onto that culture, it will be much easier for you to either actually rehabilitate your business, taking advantage of this new regime, or to basically seek dispensation from the lenders. Thank you.
Thank you, sir. Mr. Himanshu, your thoughts?
Yeah, thank you. Actually, this was a nice session, I would say. Just taking cue from what Neeraj has said, continuing my thoughts there, is that definitely now there is a mechanism which is for the benefit of the MSME. They need to evaluate it as one way to restructure themselves. But at the same time, despite the fact that I mentioned that every MSME is unique in terms, and MSMEs are driven primarily by the promoters group. So if every MSME would have unique circumstances and situation, characters, and organizational business culture. I would say that because of this new regulation in the code, there is now a set standard as to how they are expected to conduct their business in terms of when it comes to, let's say, PIRP, what all are the non-compromisable or non-negotiable aspect that they have to ensure a standard way of operation. And I think through this regulation, a little bit of push, from the regulators to get themselves more organized. And get their acts, as Neeraj just said, document all your communication. And someone was asking, proposal was not signing. So in absence of that, how do you exchange and protect your rights and entitlements is very, very important and emerging point. And given the fact that this is a kind of an ameliorative measure from the government to address and prevent the MSME ecosystem, one has to do their responsibilities equally. So it's a mutual win-win both for the regulator and the MSME sector. One should be careful as to ensure that not just for their own benefit, but even for the transparency of the with the creators and the other stakeholder, they can be a mutual success. if we follow, the rule completely.
Thank you, Mr. Himanshu. We still have Mr. Kalyan with us. Sir, would you like to add anything to our concluding remarks? Saranya, I think you have to unmute, sir.
Yeah. Right. As all the speakers said, I think it's going to be a sea change in the thought process of how we're doing business and how we keep the entity separate and our personal things separate. Because in the MSMEs, more often than not, we see a lot of intermingling of the accounts from the private accounts being used for the business purposes. So in the flow of things, when things are going good, it is all the same. But moving forward, if they are going to give all the disclosures, and that should not come to haunt them later, I think they, as the other speakers said, they will have to become a lot more systematic and ensure that there's a clear differentiation between the business as a corporate entity and their own personal accounts. I think that is going to be a sea change. A bigger sea change will also be required from the banks, where they should really come forward. Like, I was quite surprised when one of the leading bankers, they made a statement saying, we will give our in principle approval now, but thereafter, once it's filed, then we can always take it off and then bring them under the CIRP. I think that the entire thought process itself should change, because unless you are going to trust them fully and you repose the trust, because in the Act, there is no reason the Committee of Creditors on a 66% share can recall their order which they in principle approved of. There need not be any reasons, and the NCLT cannot say anything about it. So unless there's some sort of a safeguard about how they gave an in principle approval, and after the application, unless there's been some specific acts which had been done by the corporate debtor, or they have been certain acts during that process which has made them change their thought process, they cannot just withdraw the entire process of in principle approval given, because that is not very clearly specified in the rules or regulations. So I think it's a question of building a lot of trust between both of them and making sure it goes to a win-win situation for all. And I'm sure it will work out well for all.
Thank you, sir. As we head to the, we're coming to a close of this session, I'd like to actually thank Siki for facilitating such a program, which is, I think, a real eye-opener. These kind of new concepts and your thoughts on how to structure businesses. Usually people have family or group of friends or these small proprietorship concerns. They just start the business out of enthusiasm, but fail to have a proper structure running the business forward. But I think today's point really emphasizes how structured we should be, have a proper flow chart, and be accountable, or be recording most of our actions and keep everything in black and white in our own interest. As long as we are fair, I think keeping things in black and white is always safe for all of us. So in that sense, I thank Mr. Kalyan for spending so much of time with us, the other experts, Mr. Himanshu and Neeraj, for spending more than an hour with us, and the entire team of Siki, who have taken efforts to put this thing together, and a wonderful 1.5 hours of knowledge sharing. So, gentlemen, thank you once again. I thank all the attendants for also coming here and being benefited from this program. So thank you, and hope we all meet again in a similar program, similar knowledge sharing session at a later time. Thank you very much.